What is public charge and how could this affect your green card? Could it make or break your green card filing? And what is the new rule that has been passed by USCIS? Watch this video to find out. Hi, my name is Ranchod. I'm an immigration attorney. You'll want to stay tuned to watch and learn more about this new rule that affects green card application. DHS has published a new rule regarding the public charge ground of inadmissibility. The new final rule goes into effect December 23rd, 2022. This is important because it affects I-485 applications. There's a new form that incorporates this new rule and will ask additional information from you. And so it's really important that you submit the new form that will be issued. Now, my friends, this is big news because this completely changes the landscape of the 485 application. USCIS is requesting now more information on that form. There is more information on that form regarding whether or not you will meet the public charge requirements. Now, you might have so many questions about, well, why does this matter? What's public charge? Let's dive into that. So let's talk about what is the public charge ground of inadmissibility. Talking about inadmissibility, that's just a fancy word for things that may not make you eligible to get a green card. One of them is the public charge rule. Congress established that a non-citizen's application for a visa, admission, or adjustment of status could be denied if they are found to become a public charge. That's why this rule is so important, because you can, if you don't meet these requirements, you will not be able to get a green card. That's why this is breaking news, and we want to really dive into, okay, how is this going to affect you? And I'm going to talk about this in the latter part of the video. For DHS, the public charge inadmissibility determination is based on this non-citizen's likelihood of becoming primarily dependent on the government for subsistence, and that's demonstrated through public cash assistance for income maintenance or long-term institutionalization at the government expense. Now, USCIS must apply this rule to non-citizens who are applying for the green card application, which is also known as the I-485 application. There are some narrow exceptions for this requirement, but they are narrow and generally they won't apply to most of you that are applying. Okay, that's great. So now you know there's a public charge. Well, what do you do about it? How do you play by the rules of the game? For all applicants for adjustment of status is just another word for filing for the green card in the United States, that are subject to the public charge. USCIS must consider the statutory minimum factors of age, health, family status, assets, resources, and financial status, and education and skills. Now you'll be providing relevant information about this on your 485 application and on the medical examination as well. Now, there's another form that's really important in this application besides the 485, and that is the affidavit of support. USCIS is going to favorably consider this I-864 affidavit of support. Prior to this, USCIS weighted heavily that affidavit of support, and the 485 did not have questions about income and resources and whether or not you took public assistance. We haven't seen this new form yet, so I don't know what that form exactly is going to ask you. But from what USCIS has indicated, what's been indicated in the rule, we do know that they're going to be looking at a variety of factors of whether or not you've taken public benefits in the past, and I'm going to outline that in detail in this video. USCIS is also going to consider past receipt of public cash assistance for income maintenance or long-term institutionalization at the government expense. Honestly, I think I'm very surprised that USCIS is going and DHS is going in this direction, because this is taking a step back, in my opinion, to what Trump pushed out during his presidency, where they were trying to narrow the scope of who could qualify based off of the public charge ground of inadmissibility. Now, this is going to make it much more cumbersome for you when applying for the green card application. It's adding unnecessary requests for information that may not even apply to you. And in my opinion, it's just a step in the wrong direction for the Biden administration. I'm very disappointed, by the administration for pushing out this new form, requesting these requirements. I don't think it's practical. I think the affidavit of support did a great job, but it is what it is. So we have to play by the rules of the game. Let's continue to talk about what the rules of the game are. Let's talk about what is public cash assistance. This is really important for you to know since this is one of the new rules of the game. This includes supplemental security income, known as SSI, cash assistance under the Temporary Assistance for Needy Families, known as TANF, state and local cash assistance programs that provide benefits for income maintenance. Now, the USCIS is also going to consider institutionalization for long-term care at the government's expense, such as in a nursing home or mental institution. Now, I want you to listen to this very carefully. Listen, because this may be some good news. You might be freaking out like, oh my gosh, what am I going to do? Listen to what I'm going to say. Relatively few applicants are going to be both subject to the public charge ground of inadmissibility and will also be eligible for public benefits prior to filing for the green card. This is extremely important for you to know because many of you are not eligible to apply for public benefits because you're not a citizen. So this is the good news for you, and I'm going to talk more about that in this video as well. All right, let's talk about what public assistance programs does USCIS not consider. So they don't consider non-cash benefits. Okay, well, what are non-cash benefits? Now, there is an exception to that. There's always so many exceptions in the law. The only non-cash benefits the USCIS considers is long-term institutionalization at the government expense, and they also do not consider special purpose cash assistance that is not intended for income maintenance. Let's look at what the following benefits that would not make a public charge determination. Nutrition programs, so that would be SNAP, Supplemental Nutrition Assistance, Special Supplemental Nutrition Program for Women, Infants, and Children, known as WIC, school lunch and school breakfast programs, benefits under the Emergency Food Assistance, Child and Adult Care Food Programs, food distribution programs on Indian reservations. I think this is a good policy because we don't want to be depriving people of not having enough food to eat. That's not what the U.S. should stand for. So I think this is good that at least it's not targeting people getting enough food and nutrition in their daily diet. And also, they're not going to consider health programs, so that they're not going to consider children's health insurance programs known as CHIP, Medicaid, other than support for long-term institutional care, which we mentioned earlier. Keep on mentioning this. It is important for you to know the distinctions because the law is complicated. Public assistance for immunization and for testing and treatment or symptoms of communicable diseases, health clinics, short-term rehabilitation services, and emergency medical services. Health insurance through the Affordable Care Act, any benefits related to immunization or testing for communicable disease, treatments of preventative services related to COVID-19, including vaccination, home and community-based services. The next one I'm going to be talking about can be confusing for you, and this is also good news as well. They're not going to consider housing programs as well. Under housing programs, that would include housing benefits, housing assistance under the McKinney-Vento Homeless Assistance Act. Also, it doesn't include education and child care programs, cash payments that are provided for child care assistance or other supplemental special purpose cash assistance. Child care related services, including the Child Care and Development Block Grant, Head Start, attending public school, student loans, and home mortgage loans, publicly funded scholarships and educational grants, foster care, and adoption benefits. All right, you might be thinking, well, that's great. Well, what about disaster relief programs? Is that going to subject me? In general, disaster relief programs won't subject you. Let's talk about what the specific disaster relief programs they will not consider. Any services provided under the Stafford Act or comparable disaster assistance provided by the state, tribal, territorial, or local government. Cash payments that are provided as part of pandemic or disaster relief funds, such as the American Rescue Plan Act. So this is really important that here, the cash payments here are very specific to what I just mentioned. Otherwise, cash payments could be an issue, but this is very specific and it's important that you note that distinction. Earned benefits, so for instance, Social Security, retirement benefits. You might be wondering, well, what about earned benefits? Well, they're not going to consider Social Security. They're not going to consider veterans benefits. They're not going to consider pensions. This question I also get a lot of as well. Unemployment insurance, that won't be considered either. What about other public benefits? Program services or assistance, such as soup kitchens, crisis counseling, and intervention and short-term shelter will be considered, provided by local communities or through public or private nonprofit organizations, transportation vouchers or other non-cash transportation services, job training programs, energy assistance, such as the Low-Income Home Energy Assistance Program, guaranteed income programs that are not equivalent to public cash assistance for income maintenance. Let me repeat that again. That are not equivalent to public cash assistance for income maintenance. The child tax credit or other tax-related cash benefits, including the earned income tax credit, the additional child tax credit, premium tax credit, advanced payment of premium tax credit, and state, local, or tribal tax credit. Now, I want to hit again upon an important point that I talked about earlier, and that is who can get cash benefits. Now, I want to hit upon another important point. Who is subject to this ground of inadmissibility and eligible for public benefits under this 2022 rule? There's few non-citizens in the U.S. that are both subject to the public charge ground of inadmissibility and eligible for the public benefits considered under this 2022 rule. I'm saying this again because it's really important for you to know. What's really important to note too is that this rule is what's called a totality of the circumstances rule. So what that means is that it's looking at a variety of factors. So there's not going to be like one thing that knocks you out of the gray. It's going to be something that's going to be looked at on a variety of factors based off of what's going on for you financially and whether or not you took these public cash benefits, whether or not you meet affidavit of support requirements, etc. Let's now delve into, well, what if past public cash benefits were used or are currently used? What do you do if a family member is living in the household, uses public cash assistance for income maintenance or long-term institutionalization at government expense? Would that count against the applicant's immigration status or eligibility for immigration benefits? So here, this is really important. The answer is no, because the receipt of the benefits by the family member is not considered a public charge inadmissibility determination under this 2022 final rule. This is really important because why should a family member affect you? So the family member, as described here, will not affect you. Only public cash assistance for income maintenance or long-term institutionalization at the government expense provided to the applicant, let me say that again, to the applicant, where the applicant is listed as a named beneficiary, are considered in a public charge inadmissibility determination. Now you might be wondering, well, I'm a citizen, can I lose my citizenship because I took cash assistance? No, you won't lose your citizenship because you took cash assistance. What about if you're going to renew your green card? Is that going to affect you in renewing your green card? Lawful permanent residents apply to renew their green card aren't subject to the public charge inadmissibility determination because they're not required to establish that they're admissible to the United States when you're renewing their green card. What if you're not renewing your green card, but you're already a green card holder? How will that affect you? DHS only applies the public charge ground of inadmissibility to applicants for admission to the U.S. or to applicants for adjustment of status who are already in the United States. Lawful permanent residents have already adjusted their status. So when you receive public benefits as a lawful permanent resident, it's not going to affect your status while you're in the U.S. This is a very important question that you may have that I want you to listen to closely. Does the current or past receipt of public benefits automatically result in an applicant being found likely at any time to become a public charge? No. USCIS considers current or past receipt of public cash assistance for income maintenance and long-term institutionalization at government expense in the totality of circumstances, taking into account the amount, duration, and recency of the receipt. Current and or past receipt of these benefits alone is not sufficient basis to determine that an applicant is likely at any time to become a public charge. The past or current receipt of public cash assistance for income maintenance and long-term institutionalization at government expense is only one factor, let me repeat that again, one factor that they consider in the totality of circumstances. Okay, well, what are the other factors? Other factors can include statutory minimum factors such as age, health, family status, assets, resources, financial status, education, and skills, and the affidavit of support. I just threw a lot of information at you, and I know it's a lot, so I invite you to contact our office at 916-613-3553 or post your comments below, but make sure you subscribe to continue to get important updates like this. I want to thank you for taking the time to watch this video. By bettering yourself, you're bettering your family. By bettering your family, you're bettering the world. Check out our other videos on the green card process so you can put this all into perspective, and we will see you next week. Bye for now.